Hello, everyone. Thanks very much for attending today's webinar by the Australian Law Reform Commission. I'd like to extend a very warm welcome to all of you, both those who are joining from within Australia and those who might be joining from outside Australia. My name is Andrew Godwin. I'm Special Counsel with the ALRC and a member of the team that's undertaking the ALRC's current inquiry into the legislative framework for corporations and financial services regulation. I'll be chairing today's webinar. Let me commence by acknowledging the traditional owners of the land on which all of us around Australia are located and pay my respects to their elders, past, present, and emerging. Today's webinar is the first since the publication of the ALRC's interim report, first interim report in November last year. That report responded to the terms of reference in relation to topic A and focused on the use of definitions in corporations and financial services legislation. The report invites submissions by the 25th of this month, and we certainly encourage everyone to engage with us and make submissions on relevant aspects of the report, particularly by responding to the proposals and questions in the first interim report. To date, the ALRC has produced a number of publications for this inquiry, and apart from the interim report that I mentioned, we've produced a summary of the report. We've also produced 4 background papers on topics relevant to the inquiry. These are all available on the ALRC's website, along with media articles and links to previous webinars and podcasts. So our focus for this webinar is on complexity in the legislative framework and 3 related questions. First, why is it important to reduce complexity? Secondly, where does complexity exist? And thirdly, how might we reduce and manage complexity across the various sources or levels of regulation, what we commonly refer to as the legislative hierarchy. Our comments in today's webinar will draw on the analysis, proposals and questions in the first interim report. We'll also foreshadow the further work that we'll be undertaking for the subsequent topics on regulatory design. That's the topic in the second stage. And in the third stage, topic C, we'll be looking at how Chapter 7 of the Corporations Act might be reframed or restructured to create a more coherent and effective framework. A consistent theme arising out of the consultations to date is that the legislative framework is too complex and in need of simplification. I think everyone, virtually everyone, would accept that a degree of legal complexity is necessary to regulate an industry as complex as financial services. However, most stakeholders, I think, would suggest that some aspects of complexity are unnecessary and unhelpful. And we'll discuss some of the reasons for this unnecessary complexity during the webinar. In particular, I think we see complexity in many definitions used in Chapter 7 and the Corporations Act more generally. Complexity is often compounded by the large number of exclusions, exemptions, and exceptions that apply. The definitions of financial product and securities, both of which are interconnected depending on the area of regulation, are prime examples of complexity. The definitions of financial product advice and retail client are other examples. The challenge with complexity, of course, is that it makes the law difficult to navigate and comply with, at least in a meaningful sense. It also obscures the underlying policy goals and detracts from an understanding of the fundamental norms that should guide behaviour and inform outcomes. And in this regard, the inquiry and its terms of reference speak directly to the recommendations of the Financial Services Royal Commission, 2 recommendations in particular. First, as far as possible, exceptions and qualifications to norms of conduct should be eliminated. Secondly, the fundamental norms of behaviour that underpin the rules should be identified. In fact, Commissioner Haynes suggested that legislation should make explicit the connections between rules and fundamental norms to explain better the purpose behind particular rules. How those connections might be made more explicit and how complexity might be reduced and managed over time are issues on which the ALRC continues to work. With me today, I have 4 colleagues, Nicholas Simoes da Silva, Chris Ash, Phoebe Tapley and Will Isdale, all of whom are Senior Legal Officers with the ALRC. Each of them will refer to different aspects of complexity and how it's been examined as part of the interim report. By way of broad outline, Nicholas will speak to the question of why, as in the topic of today's webinar, why do we have a degree of complexity in the legislative framework, somewhat unnecessary complexity? And Nicholas will talk about the work that the ALRC has been doing to identify and assess complexity within the legislative framework. Chris, Phoebe and Will then discuss the where question in the topic, namely, where do we see complexity? What are the key areas of complexity? And they'll also speak to the how question, namely, how does the ALRC propose to reduce complexity and how should complexity best be managed over time? Chris will discuss the defined concepts of financial product and financial service and the relevance of the legislative hierarchy in that regard. Phoebe will make specific reference to financial product disclosure and Will make specific reference to conduct obligations. We're hoping to have as much time or leave as much time as possible to questions at the end. I'd like to thank all of those who've already submitted questions when they registered their attendance. For those who'd like to ask a question during the webinar, please feel free. We'd welcome questions from all of you, although we may not be able to get through all of them. But if you would like to ask a question, please email the question to our general email address, and that's financial.services@alrc.gov.au. Our colleague Michael Payton will be collecting questions and passing them on to us, and my apologies in advance if we don't get to all of the questions. So, turning first to Nicholas, what I'd like to do is ask you, Nicholas, what are the causes of complexity? What is it that makes the regulatory framework complex? And where has the work of the ALRC taken it in this regard?
Thanks, Andrew. I think the starting point, as you noted, is that there is inevitably a degree of complexity in the law and in regulation. But I think that idea can sometimes make us assume that a very complex law is inevitable. And I think what our inquiry has shown is that that's not the case, that we can reduce complexity and that it is desirable to do so. And so the starting point there, though, in terms of simplifying the law is then what features of the law and of regulation add complexity, and to what degree are those necessary or unnecessary in their complexity. And so if we think about, the ALRC has identified over a dozen features that make legislation more complex. And for each of them, we've developed a range of metrics for thinking about their complexity. And those broadly float around structure and language of legislation. And I mean, to think, for example, about definitions and cross-references. So both of those add complexity to legislation, and they can be measured in their use and just their overall number. Both are useful and necessary. So definitions can clarify meaning, and cross-references can reduce the need for repetition. But they can also quickly become unnecessarily complex in their use and number. So a provision comprised of too many defined terms and cross-references may simply fail to effectively convey meaning, because to understand it requires that regard be had to so many other definitions and other sections of the Act. And so every feature we examined, there was always a question about whether it brought necessary and unnecessary complexity, and then how we would go about measuring that. And that's what our second background paper and Interim Report A really sought to do. But if I can really focus on where I think our inquiry has highlighted the most unnecessary complexity, and that's in the legislative hierarchy, and in some ways a failure to effectively use a legislative hierarchy. And so there are three, and just to reiterate what that legislative hierarchy, what we mean by that, that's where law should go. So should it go in the Act or regulations and other legislative instruments, or even in administrative instruments or soft law guidance? So thinking about where law should go is what the legislative hierarchy is about. And so we identified three features that can introduce unnecessary complexity. So first is the proliferation of legislative instruments without thematic consolidation. And so there's clearly a better alternative, which is to reduce the number of legislative instruments by consolidating them thematically, thereby improving the navigability of the legislation. The second real source of unnecessary complexity is inconsistency. So a lot of legislative hierarchies adhere to generally accepted norms. So that means that people can broadly understand where they would go to find certain types of law, such as criminal penalties, high-level criminal penalties, or exemptions and exclusions. And so they know where to go in the hierarchy. And at least, even if a legislative framework doesn't have that adherence to generally accepted norms, a less complex framework still is internally consistent. So it may depart from those norms, but it still makes sense in and of itself. And regimes that don't have that really are very complex, as we found in our inquiry. And the last one, last feature of unnecessary legislative complexity is dark law. And what we mean by that is modifications and notional amendments, and that is where an instrument amends the text of another act, generally another instrument, generally an act of Parliament, without actually changing the text of that instrument. So the act is to be read as if it were changed. And those obviously affect the navigability and the complexity of legislation, and they can be unnecessary in the sense that their benefits, adaptability and flexibility in the law, which a regulator might be able to amend an act to fix up problems, but those benefits can be preserved in other ways through better law design, moving a provision that is frequently notionally amended lower down the legislative hierarchy so that it can be directly textually amended by that regulator. So you can avoid these problems outside of crises where more of this may be necessary, but generally good law design can fix quite a few of the aspects of unnecessary legislative complexity. Thanks, Andrew.
Thanks, Nicholas. You've been closely involved in all of the data analysis that the ALRC has conducted to date in relation to the legislative framework. And if I might say so, the data analysis that the ALRC has conducted in this regard has been quite groundbreaking and also quite revealing. Indeed, we devoted a whole chapter on data analysis in chapter 3 of the first interim report. Further detail is contained in the second background paper that we released on complexity and legislative design. To date, much of our focus has been on identifying the metrics or indicators of complexity. Going forward, we intend to build on this by developing a complexity framework that measures the total complexity of an act. So, Nicholas, I'd like to ask, what metrics or indicators do we have that the regulatory framework for corporations and financial services may be unnecessarily complex?
Thanks, Andrew. I think unsurprisingly to many of the listeners, there are a lot of indicators and metrics. So as Andrew noted, we undertook a lot of data analysis, and that included analysing data across every act of Parliament, as well as comparable legislation in the UK and New Zealand. And what this really highlighted is that degree of unnecessary complexity in the corporations legislation. And so thinking about definitions, for instance, so the Corporations Act has well over 1,000 definitions. And in absolute terms, that's enormous. I mean, relative to its size, we found it was less surprising. It's a big act, so you would expect a lot of definitions. But in terms of that sheer number of definitions and the way it uses them in particular, it makes it the second most definitions-dense act on the Commonwealth statute book, so well over 1,200 acts. So again, a design choice there to make extensive use of defined terms. Another example is cross-references. So well over 14,000 cross-references in the Corporations Act, and that's internal cross-references, so to other sections. And then you've got hundreds more external cross-references, which might take you on a merry trip across the statute book. And in its sheer number, that brings a significant degree of complexity to answering, important questions such as what is a financial product? You are often taken around the Act to answer that kind of question. And so what the research has really highlighted, the data analysis, looking at the UK, New Zealand, and comparable Commonwealth regulatory acts, is where that unnecessary complexity lies, and really that it is in part the product of design choices and the overuse of particular legislative features. So on a variety of metrics related to structure, language, conditional statements rather, and definitions, we found New Zealand and UK legislation significantly less complex. And that's financial services legislation. So they're dealing with a similar ground, but they're doing it in a less complex way. And also looking at other Commonwealth regulatory acts, we found the Corporations Act is quite, it really does stand out in its use of notional amendments, in its use of proliferating legislative instruments, and an inconsistent legislative hierarchy. And so it's that use and overuse of particular legislative features that introduce, in large part, a lot of the complexity. And if I can really focus on that legislative hierarchy issue, so thinking about proliferating legislative instruments. So the Corporations Act has more legislative instruments than the vast majority of Commonwealth acts. And it has the corporations regulations are equivalent to the 8th longest act of Parliament in themselves. So the Corporations Act is just the tip of an iceberg under which sits this vast and constantly evolving body of law. And that's not necessarily a problem, that the size of the body may not be the issue, but it's the way that it's spread across so many unconsolidated legislative instruments. And second, that it really is inconsistent in its design. So a reader of the Corporations Act and a visitor to this legislative framework will really struggle to make sense of where they should look for particular types of information. There's not the kind of principled hierarchy that would reduce unnecessary complexity. And so, for example, Section 117 of the Corporations Act contains the detail required to apply for a company. So it's 3 pages of what should go in an application form, and that's in a primary statute. But the same type of information when applying for a market license is contained in the corporation's regulations. So even something like, what should I put in my application form? You don't exactly know where you'll need to go to find it. And the one answer is that may not even be in the Act. Maybe it should be in asset guidance, for example. So thinking about that inconsistent legislative hierarchy, we've been able to really highlight that through our analysis. And then the last one to dwell on is that issue of dark law. So the Corporations Act is really unique in how it uses notional amendments. So it uses well over 100 instruments to notionally amend the Act, which in itself accounts for 30% of all instruments notionally amending an Act of Parliament. And that's far more than the second most amended Act. So that you can see the analysis really highlights that is a key part of the legislative framework, but one that we think in our research on the financial services licensing framework, the number of notional amendments there make that legislative framework really complex to manage. So I'll finish there, but I'll emphasize also that this analysis is preliminary, and in our interim report A, question 1 asks for feedback on this model, thinking about complexity in this way, and what further data we should generate, obtain, or analyze. And so I'd encourage all stakeholders who have an interest in understanding complexity in the Corporations Act and their experiences understanding complexity to make a submission to the ALRC. Thanks, Andrew.
Thanks, Nicholas. It's interesting to reflect on why we see so much complexity in Australia by comparison with other jurisdictions such as the UK and New Zealand, as you mentioned. It could, of course, be partly a result of the 2 decades of cumulative additions and amendments to the Corporations Act without perhaps having the benefit of a thorough spring clean. And although there's no doubt, I think that this is an important factor in the complexity that we see, complexity is also due to a lack of clarity or coherence in respect of the legislative hierarchy, as you mentioned. Namely, what laws should go where and how should the law best be organised and structured to achieve a coherent and navigable framework. What I'd like to do now is to turn to the where question in the webinar topic, namely, where do we see complexity? What are the key areas where the ALRC has identified opportunities to reduce complexity? And so I'd like to start with you, Chris. The ALRC makes several proposals in relation to the defined concepts of financial product and financial service. What complexities arise in relation to these 2 concepts?
Thanks, Andrew. Well, when I first started thinking about these sorts of questions and started thinking about how is it possible to write a whole chapter about simply these 2 defined terms, financial product and financial service, I did wonder if it was possible because they sound fairly innocuous. They've been around for 20 years and people use them all the time. And so it didn't sound like they were that big a deal. But when you do reflect and look at how they work and how the legislation puts them into practice, it's much more revealing. And I think it shows that there are really 3 main sources of complexity. So the first is that at the end of the day, these are both artificial concepts. They're just labels that are given to intangible things so that we can bring them together and regulate them in a certain way. There's a kernel of an idea in the concept of a financial product. It's got something to do with money. It's something you might buy or sell. But other than that, the label doesn't tell you much. And the same applies in the case of financial service. You can probably point to one without too much trouble, say operating a bank or getting some financial advice. But in the abstract, they're much harder to grasp onto. Now, as it turns out, the Corporations Act actually does a fairly good job of defining financial product in that more abstract sense. And it uses a functional definition to do that. So the idea is that the definition focuses on what financial products typically do, such as making an investment, like buying shares, managing financial risk, which could be taking out insurance, or making non-cash payments, so paying with your debit card on an EFTPOS machine. But it's after that functional definition that things start to get much more complicated in the legislation itself. So those ideas themselves of making an investment, non-cash payments and managing risk, they are themselves defined by the legislation. So that's 3 more definitions you need to consider. And then on top of those, in the Act itself, there's a list of specific inclusions that are deemed to be financial products, whether they meet that functional definition or not. And then there's a list of specific exclusions, things that are deemed not to be financial products. And a second source of complexity, which Nicholas touched on earlier, is the use of regulations and other instruments to essentially change these definitions as and when it's seen to be needed. So when looking at financial products that are included, one not only needs to look at the list in the Act, one also needs to consider the regulations, and one also needs to consider any number of legislative instruments that are also out there. And it's the same in terms of financial service. There are several regulation-making powers, and so regulations can be spread throughout the corporation's regulation that might say something is or is not a financial service. And I've tried explaining it using words, but actually it's almost easy to explain visually. And so we've included a couple of flowcharts in the first interim report. I'll give you the numbers, Appendix C6 and C7. And what I think they help show is the sort of winding path that a reader has to take if they want to definitively answer the question, is this a financial product or not? And that takes me to the third and final source of complexity that I'll just briefly mention. And it's one that a fair few people are probably already aware of. And it's the fact that there are different definitions of both financial product and financial service, as between the Corporations Act on the one hand and the ASIC Act on the other hand. So the idea behind these acts and the provisions having different coverage is perfectly sound. It makes sense that licensing, for example, only applies to some products, whereas the consumer protection provisions in the ASIC Act will apply to a whole lot more. But it's using definitions, and especially complicated ones like these, to do that boundary setting work that actually just creates more complexity. One of the examples that we've used in Interim Report A is the case of chameleon mining. And in that case, the issue was whether a particular litigation funding agreement was a financial product under the Corporations Act or not. And in the New South Wales Court of Appeal, the judges were split as to whether it was a type of derivative, a derivative itself being a specifically defined financial product in the Corporations Act, whereas the High Court actually thought, well, it's actually a form of credit. So therefore, it's not a financial product within the Corporations Act definition. And even though the High Court didn't have to say as much, as a form of credit, it would nonetheless be a type of financial product under the ASIC Act. So I think that gives a sort of brief overview of the complexities, Andrew.
Thanks, Chris. What's particularly interesting, I think, is that even though the Act currently has a list of things that are financial products and a list of things that aren't financial products, challenges continue to arise as new products emerge, some of which have different functions depending on the purpose for which they are used. So I'm thinking here, Chris, about crypto assets such as cryptocurrencies and tokens in initial coin offerings. And it seems to me that in the areas of innovation and technology in particular, it's becoming increasingly difficult to regulate by reference to labels, as you mentioned. I note that ASIC has stated in its regulatory guidance and elsewhere that the regulation of crypto assets is based on the particular characteristics, rights, and features of the crypto asset in question. And so it seems to me increasingly that we need to move towards a more functional approach to regulation and away from regulating purely by reference to labels. So, Chris, in terms of how we might reduce the complexity in this regard, what have we proposed in terms of dealing with the issues, and what would you like to draw to everyone's attention in that regard?
Well, I think the basic idea behind the proposals that we put forward are just to make it easier to tell when something is in the regime or when something's out of the regime, and fundamentally so that you know what part of the law applies when. Because it's this boundary setting work that I mentioned before that is really important. And the terms financial product and financial service end up acting as hooks or triggers for obligations. If something is a financial product, you must do certain things. If it's a particular type of financial product, you must do certain other things. And so that makes it really important that these boundaries are able to be understood. And our aim is to make essentially that task simpler. So the first proposal we've made, and which is related to your comments, is that we think you could do away with the list of specific inclusions to the definition of financial product. The idea behind these inclusions so far has been to include products that may not meet the functional definition, and it's also been to provide clarity about some other products. But when you stop and look at this fairly extensive list, there are very few, if any, that probably don't meet the functional definition. And it also causes you to stop and think, well, actually, if something doesn't meet what we've said is the fundamental definition of a financial product, then why is it being regulated in this way? And it's those sorts of questions that really get glossed over under this current definition. So as a result, it does mean that we've suggested relying more heavily on the functional definition. And we've called this the if it's in unless it's out approach. So to put it differently, to figure out if something is a financial product, you consult the functional definition, and then you consult a list of exclusions from that. And it's either in or it's out. And these exclusions can be changed as and when they need to be. So for example, there would be fewer exclusions from the ASIC Act consumer protection provisions than there would be from the licensing provisions, as I touched on earlier. Now, of course, there are other ways that this could be done. For example, you could simply use one big long list of everything that is a financial product or a financial service that is to be regulated. And you might call that the it's in, if it's not in, then it's out type of approach. Now, that's actually how financial service is defined. There's no functional definition of financial service in the Corporations Act. And that's also the way that the United Kingdom financial services legislation stakes out the boundaries of its regulatory regime. But the idea behind the functional definition has always been, since it was enacted in 2001, that it could capture new and emerging products as they enter the market. And so taking a specific list approach would mean that that list would constantly be playing catch up if these new and emerging products were to be regulated. The second proposal we've made, and one that I think is actually a fairly straightforward one, is that there should be just one definition of financial product and financial service consistent between the Corporations Act and the ASIC Act. The main difference between the two of them currently is really centred on the exclusion of credit. Credit's excluded from the Corporations Act, but it's included within the ASIC Act definition. And so what we suggested is incorporating credit within the functional definition of financial product, and then, as I mentioned before, excluding it as is necessary. Because of the extensive use of these inclusions and exclusions so far, there hasn't actually been that much attention paid to the functional definition. It seems to be operating well. There are a couple of judgments about it, but there's really not a whole lot on it. And so that's something that we particularly welcome people's views on. And including credit in this way also opens up the possibility of consolidating the currently separate regulatory regimes that are in the National Consumer Credit Protection Act and the more general financial services regulation in Chapter 7 of the Corporations Act. And that's something that we'll return to in Interim Report C. And the third proposal that we've made, and the final one that I'll mention, is to simplify how the legislative hierarchy is used with these definitions. So instead of needing to consult the Act, regulations and other instruments, so that you can figure out if something is a financial product or a financial service, we suggested using application provisions in the Act and then housing exclusions in a single piece of delegated legislation. So as a simplified example, an application provision might say, this part applies to financial products, except for those in the implementation order, which is what we've notionally called the delegated legislation. So that if someone wants to figure out if something is a financial product or is covered by that part of, say, the chapter, then the person simply needs to consult the application provision and then the corresponding exclusion section in the implementation order. The difference between that approach and the current approach is, I think, easier to explain visually again. So we've included a couple of flow charts at Appendix C14 and C15 this time, which I think when you compare them to the flow charts I mentioned earlier, really show how much potential there is for simplification in adopting this method. And what they also show quite well is that the number of exit ramps out of the regime, basically ways that something can be carved out, can be halved. So in the case of financial product, it can be the exit ramps can be reduced from 4 to 2. And in the case of financial service, the exit ramps come down from 7 to 3. So we think there's some great potential there for simplification, and we would love to hear people's thoughts on that.
Thanks, Chris. As you mentioned, having fewer exit ramps from the various regimes would certainly assist in navigability. As we've often discussed within the team, there are two threshold questions that are particularly relevant to the ALRC's inquiry. First, how easy is it to find the law? And secondly, how easy is it to understand the law once it's been found? A related question, of course, is how easy it is to work out how to comply with the law in a meaningful, substantive way. As Chris mentioned, we'd certainly be interested to hear everyone's views on the legislative hierarchy model that the ALRC has proposed in Interim Report A. And as Chris mentioned, that involves putting application provisions in the Act and housing exclusions in a single piece of delegated legislation. So what I'd like to do now is to continue with our discussion about specific areas of complexity by looking this time at disclosure. And Phoebe, the ALRC makes a couple of proposals in relation to the regulation of financial product disclosure. Why is reform needed in this area, do you think?
Well, we've heard from a number of stakeholders over the course of this inquiry that the provisions regulating financial product and services disclosure are particularly complex. And those observations have really been borne out by our primary analysis of those provisions. So we found that the disclosure provisions tend to come out on top on a number of key complexity metrics that we've looked at for this inquiry. So first, it's worth mentioning that the provisions relating to disclosure are vast. Our data analysis suggests that disclosure is the topic that takes up the most legislative space within the Corporations Act. So Part 7.9, for example, which of course deals primarily with product disclosure statements. So it's just a subset of the disclosure requirements for financial service providers. That contains over 45,000 words, making it the longest part within the Act. And although the length of legislative provisions is not necessarily a problem in and of itself, we do discuss in the report that it can be both a symptom and a driver of complexity within a legislative framework. And I think that both are certainly true in the case of disclosure. So the volume of Part 7.9, for example, speaks to the breadth of circumstances and products that are captured by that particular regime, and also the prescriptiveness of many of those requirements in relation to the form and content of disclosure documents. And in terms of being a driver of complexity, I think it's fair to say that the volume of the disclosure provisions can present challenges for, as Andrew mentioned, first finding the law and then understanding what it is you're required to do. And that is particularly the case when we take into account the nature and extent of legislative instruments that vary the disclosure requirements as set out in the Act. So as at the 30th of June last year, we had identified 84 in-force ASIC legislative instruments of potential relevance just to Part 7.9. Which again is more than for any other part of the Corporations Act. Then on top of that, there is a significant volume of relevant regulations. And again, as is the trend, Part 7.9 of the Corporations Regulations contains the most words of any of the parts within the Corporations Regulations. Then, as Nicholas has already alluded to in his comments, a particular source of complexity is the way in which those regulations and ASIC legislative instruments interact with the primary law and the opacity or the lack of transparency in how that happens. So by way of example, if we look at the shorter PDS regime, which applies to the superannuation products, margin loans, and simple managed investment schemes, for the reader to understand how that particular regime works, they first need to know that it exists because it's not referenced at all in the primary law. And then they need to know where it is in the Corporations Regulations, which is not just in one spot, it's across many regulations and several schedules to the regulations. And those regulations and schedules serve to omit certain provisions and substitute certain provisions so that effectively you have a parallel version of Part 7.9 which applies to those particular products, which can be quite hard to piece together on your own if you haven't come across it before. So we have actually attempted to illustrate the complexity of those particular arrangements in a flowchart that again can be found in Appendix C of the Interim Report at Appendix C.11 in case anyone is interested. So I think it's probably fairly uncontroversial to say that the complexity of disclosure provisions at the moment aren't working for consumers or for financial services providers. Something that we've heard from stakeholders over the course of this inquiry is that the consequence of this level of prescription, particularly in Part 7.9, as well as other disclosure documents like statements of advice, means that it's very resource intensive to prepare a disclosure document, and sometimes that may limit the ability of a financial service provider to offer flexible and affordable services to their clients. And then on the other hand, we now have a number of studies, including one from ASIC quite recently, that raised doubts about the usefulness of the disclosure documents that we generate pursuant to these requirements. So in summary, I think it's fairly clear that disclosure is an area that is particularly ripe for reforms to reduce complexity, and that's why it's one of the areas in which we've focused our attentions for Interim Report A.
Thanks, Phoebe. I'd like to ask a follow-up question, but let me just say that we've already begun to receive some really interesting questions. So hopefully we'll get to them at or around 6 o'clock, Australian Eastern Daylight Saving Time, that is. And could I also ask everyone to turn off their video if you can, just so that we don't get any interference in that regard. So Phoebe, the ALRC's made a proposal in relation to the standard for disclosure, and in particular, we've talked about an outcomes-based standard for disclosure. How do you think the introduction of this kind of standard might reduce complexity and assist in terms of setting out the disclosure requirements and also perhaps working out how to comply with them?
Sure. So the idea behind this proposal is to essentially recalibrate the legislative framework for financial product disclosure in service of a couple of key objectives. So first, to clarify the substance and intent of product disclosure obligations by really putting that object of disclosure up front and center, and thereby to encourage meaningful compliance with that obligation. And secondly, the idea is to better accommodate the diversity of products and circumstances which we know that are captured by the disclosure requirements in Part 7.9. And the thinking behind this proposal is closely tied to the discussion in Chapter 10 of the Interim Report, which sets out the potential legislative hierarchy model, which we'll be exploring further in Interim Report B later this year. And Chris has already mentioned one aspect of that model, which is the consolidation of exclusions and exemptions in a single legislative instrument rather than across multiple sources. The other aspect of the model, which we're inviting feedback on, is the introduction of a power to make what we describe as thematically consolidated legislative instruments, or rules. And the idea behind that approach is that rules could replace much of the prescriptive detail which is currently furnished by the Corporations Act itself, as well as by the Corporations Regulations and many ASIC legislative instruments. So we think that applying this particular model to the product disclosure requirements in Part 7.9 has the potential to reduce complexity and improve the navigability of the law in a few ways. So firstly, it would remove much of the volume from Part 7.9 of the Act by stripping it back to the more fundamental aspects of the regime, so the key obligations, when they apply, what are the consequences of non-compliance. And more importantly, it would better accommodate the need to tailor the detail of those disclosure requirements for different products and circumstances. Because although there were aspirations of greater uniformity in product disclosure requirements when Part 7.9 was introduced, and at the time of the Wallace inquiry in particular, the reality is that we have seen a need to adapt those requirements for the range of circumstances which are captured by Part 7.9. So recognising that the standard requirements are not so standard anymore, I think there is a strong argument for reshaping the legislative framework to accommodate the need for tailored requirements without the need for a complex web of notional amendments across a range of regulations and instruments, which presents challenges for navigability as well as the risk of incoherence because it's spread across so many different sources and we can't see how it all fits together as a whole. So in Appendix E of the interim report, we have supplied you with some prototype drafting, which is just intended to illuminate what this might look like. But importantly, there is flexibility in where you might draw the line as to what might be best housed in the Act versus what might be better placed in these rules or in a consolidated legislative instrument. But ultimately, whenever you're doing that exercise, the aim would need to be to avoid including the kind of detail in the Act which necessitates frequent modifications in order to accommodate different circumstances or changes in industry. So to the extent that that kind of detail is necessary, it might be better prescribed as rules, with different rules applying to different products as needed. The other possibility that I want to mention, which this model sort of opens up, is for greater reliance to be placed on an outcomes-based standard for product disclosure, as we've suggested in the proposal. So this would provide product issuers with greater flexibility to use their own professional judgment to ascertain what kind of steps need to be taken to meet the standard based on the nature of their product, the risk profile, the target market for the product, and so forth. And then we imagine that that general obligation would still be supplemented by more detailed requirements where there may be a genuine need for prescriptions, such as in relation to costs and fees, for example. But in terms of meeting the general obligation to provide disclosure, there's a possibility of giving greater flexibility to industry to think about what more innovative disclosure means might better serve the information requirements of their clients. So of course, we recognise that that would represent a shift in the current approach, but given the morass of disclosure requirements in the current law and the relative consensus that these particular disclosure requirements are not necessarily serving the policy objective of equipping consumers with the information they need to make informed choices, we thought it would be appropriate to present this as just one of the options that would be available to policymakers under the broader model that we have proposed for managing complexity through legislative hierarchy. So, of course, we're very keen to receive feedback on that broader model for legislative hierarchy, as Andrew has already mentioned. And of course, that's something that we'll be developing in much greater detail as part of Interim Report B later this year. So any feedback we receive will be feeding into that work. And equally, we would appreciate any views on the proposed application of the model to financial product disclosure in particular, and the possibility of adopting some kind of outcomes-based standard for disclosure as part of that model.
Thanks, Phoebe. And I might take this opportunity to mention that in Interim Report A, the first interim report for the inquiry, there are prototypes of the type of legislative hierarchy model as applied in the context of licensing and disclosure. So we've set out there, as it were, a map or example of how the changes in relation to the legislative hierarchy model might work. So I think, Phoebe, you've highlighted the extent to which disclosure really is quite an unwieldy thing at present, and how it is an area that's ripe for reform. Let's now turn to the final area of complexity, and what we'll be focusing on now is conduct obligations. And I think this is an area in which questions concerning norms, how to make the connections between norms and rules more explicit, and more generally, how to facilitate meaningful compliance, all of these questions become particularly relevant. And so, Will, I know you've been working very hard on this area yourself. The ALRC in the interim report makes a number of proposals in relation to conduct obligations. These are obligations that are imposed on financial service providers. Why might the provisions regulating the conduct of financial service providers be seen as complex? And in particular, why are they unnecessarily complex, do you think?
Thank you for the question, Andrew. So the Corporations Act, the ASIC Act, the National Consumer Credit Act. All of these acts contain numerous provisions that either prohibit certain conduct, like misleading and deceptive conduct or unconscionable conduct, or they impose positive obligations, such as the obligation on financial services and credit licensees to act efficiently, honestly, and fairly. I think that there are two key reasons why the law in this area might be considered to be too complex, and they're related. The first is that sometimes the law is too prescriptive. And the second is almost the inverse, which is that sometimes there is too much ambiguity. There are requirements that are vague or amorphous that could do with more clarity. And both of those problems can make it very difficult to determine how the law will apply in a specific circumstance. So if I start with the problem of law that is too prescriptive, this has been a common theme that many of my colleagues have already spoken about. So existing law will sometimes prohibit conduct by reference to a broad standard like fairness, but then it will also contain numerous other prohibitions against more specific conduct that might thought to be simply examples or instances of conduct that contravenes the broader standard. And relatedly, there is a proliferation of provisions which relate to similar conduct. Often each provision is subject to highly technical threshold conditions, and it makes it very difficult to work out which provision or provisions will apply in any specific circumstance. And a good example of this is the provisions which relate to misleading or deceptive conduct or false or misleading representations. So for example, section 1041H of the Corporations Act prohibits misleading or deceptive conduct, but so too does section 12DA of the ASIC Act. 12DB of the ASIC Act prohibits false or misleading representations in general, but then 12DC specifically prohibits false or misleading representations in relation to financial products that involve interests in land. And that's only the tip of the iceberg of provisions that are broadly related. There are, for example, at least 14 provisions in the Corporations Act alone that relate to defective disclosure or information and false or misleading documents. We're not the first to point out this proliferation of provisions. So, for example, in the case of Winge Caribee, Justice Rary was almost led to despair, quote, "Why does a court have to waste its time wading through this legislative porridge to work out which one or ones of these provisions apply, even though it is likely that the end result will be the same?" And similarly, Emily Klotz has observed in a journal article that lengthy and intricate definitions and drafting nuances in many of these provisions have created pointless distinctions, and parties must now spend considerable time preparing and presenting submissions in respect of technical threshold questions. So, Andrew, that's the problem of too much prescription. The other problem of too little clarity is evident in some of the law's broader obligations, such as the obligation to act efficiently, honestly, and fairly on financial services and credit licensees. So noticeably, none of those constituent terms are defined in the legislation. In the case of the first word, efficiently, the courts have actually held that it has a meaning other than the lay meaning. So the lay meaning might be to get more output from the same input. But the courts have said that what it actually means in this context is it implies a standard of competency or of being capable. Now, in relation to fairly, well, it's obvious that that is incredibly uncertain, and the Act also provides little guidance. In other words, and then finally, I would observe that there is uncertainty as well as to how that obligation is to be understood as a whole. So does it impose 3 separate requirements, or does it impose one requirement where you read each of the terms as conditioned by the others? There is conflicting case law on that issue, and that might be thought to be a problem given the centrality of that obligation to the legislative regime. Now, Andrew, picking up on something you also noted at the outset, there's also arguably a lack of clarity in the law as to some of the overarching principles or objectives that underlie the more specific provisions. And this was something that Commissioner Haynes spoke about in the Financial Services Royal Commission. So he observed that there were certain norms which he identified that he said underlay the existing law, but those norms were not currently given statutory expression.
Thanks, Will. The lack of clarity that you mentioned obviously affects the ease with which regulated persons can comply with conduct obligations. And of course, this is an area in which people in industry often say, well, clarity is needed, but equally certainty is needed, because without certainty, we won't know how to comply. And we often see this argument being used as the basis for resisting the adoption of more principles-based legislation. And I think the challenge, as I think many people would acknowledge, is that greater detail or prescription, as you mentioned, doesn't necessarily lead to greater clarity. And of course, we see this in the proliferation of prohibitions that you mentioned. And indeed, in some cases, greater detail may lead to compliance in form, but not compliance in substance. So any reform in this area really does need to take into account the difficult balance to strike between, on the one hand, minimising complexity, and on the other hand, maintaining consumer protection. And of course, we don't want simplification of the law to be read as any weakening of consumer protection. So how does the ALRC propose to minimise the complexity of these provisions whilst at the same time maintaining appropriate protections for consumers?
Well, Andrew, perhaps I'll tackle that by reference to those two problems of too much prescription and too little clarity. So in relation to too much prescription, the ALRC's aim here is to achieve the current state or effect of the law, including the broad scope of the existing prohibitions, but just to achieve that effect with fewer provisions. So in other words, to consolidate and rationalise the legislation. So to take the example of Section 991A of the Corporations Act and 12CA and 12CB of the ASIC Act, each of those provisions prescribes unconscionable conduct. Now, the provisions in the ASIC Act apply more broadly than the provisions in the Corporations Act, and 12CB applies more broadly than 12CA does because it captures unconscionable conduct, including unconscionable, not confined by the meaning that that term has come to have at general law. And so it's arguable that you could seek to rely simply on the broadest of those three obligations if it already captures all of the conduct that would be caught by the other two more specific provisions. The ALRC has also raised the possibility that we could consolidate provisions that prohibit misleading or deceptive conduct, as Justice Rary's decried, false or misleading representations, and also to consolidate the multitude of provisions that relate to defective disclosure or information and false or misleading documents. So that's the proliferation problem. In relation to the lack of clarity problem, I spoke about how that particularly arose in the context of the broad, efficient, honestly, and fairly obligation. Well, in that case, we might, for example, try to address that uncertainty in the case law of whether it's three obligations or one by making a choice one way or the other. It could be that you separate them out into three separate obligations, make clear that they stand alone and are not conditioned by each other. In relation to efficient, which I said the cases have come to ascribe a meaning that is different to the lay term, well, we might replace that word with a word that intuitively corresponds to the meaning that the courts have ascribed to it. So we suggest, for example, that the word professionally or potentially competently would do that job. And finally, in relation to what does the Requirements Act fairly mean, we suggest that we could include a list of non-exhaustive examples of conduct that would be likely to contravene that standard. And then finally, I spoke about Commissioner Haynes' observation about a lack of clarity as to the underlying principles or norms in the legislation. And so the ALRC has raised the possibility of enacting a series of norms as an objects clause. And in the Royal Commission, Commissioner Haynes said that he thought there were 6 norms that reflected the intention of the existing law. And those were to obey the law, do not mislead or deceive, act fairly, provide services that are fit for purpose, deliver services with reasonable care and skill, and when acting for another, act in the best interests of that other. The idea behind enacting norms such as those in an objects clause would be to more effectively guide regulated entities by enhancing the expressive power of the law, and potentially also they could serve as a useful yardstick for courts when interpreting some more ambiguous provisions. So Andrew, those are just some of the ideas the ALRC has in relation to conduct obligations, but we would really greatly appreciate the feedback of all interested stakeholders on those ideas before the 25th of February. Thank you.
Thanks, Will. We've been remarkably punctual in terms of reaching the end of the first hour, leaving ourselves 30 minutes in which to discuss questions and provide some answers. So what I'd like to do is to invite all of the members of the panel back onto the screen. And what I'll do is just take up some of the questions we've received and direct them to various members of the panel. And I might take a couple of the questions myself, if I may. So, as I said, we received some questions when people registered, and for that we're very grateful. And we've also been receiving quite a few questions during the course of the webinar. So the first question that I'd like to focus on is one from Jamie Hoy at IOOF, who asks, how does the ALRC see their proposals proceeding in light of the quality of advice review? Now, the quality of advice review is a review that's being undertaken by Treasury, albeit through an independent reviewer. And Treasury's already prepared draft terms of reference and has consulted on that. But it's a good question. How does that interrelate with the work that we're doing? And how might it support and inform the work that we're doing on topics B and C? And finally, of course, in relation to the final report. So as many of you would be aware from having read our terms of reference, the inquiry that we're conducting is a technical one. That's probably come through quite clearly from all of the interesting issues that we've discussed during the course of this webinar. But even though we're not focusing on policy recommendations, although we have come very close to identifying areas in which policy might be somewhat unclear or in which the policy settings might be given greater definition, it's nonetheless, I think, important to recognise the extent to which clarity in the design and expression of the law is premised on clarity in the underlying policy settings. To put it simply, what are the goals or objectives that the law is trying to achieve? And unless you have clarity in that, it's very difficult to know how to implement or comply with the relevant rules. So the quality of advice review will provide clarity in relation to the policy settings and will assist our inquiry in that regard. In particular, and based on the draft terms of reference for the review that we've seen, the review will inform the question of whether a more intuitive label should be chosen for this concept of general advice, which is the subject of one of the proposals in the first interim report, and also whether the requirements should be adjusted for different types of advice. The proposed review will also cover a number of areas that are relevant to the ALRC's inquiry, including reducing complexity and duplication in relation to compliance obligations. And that obviously has an impact on the cost of financial advice, and also whether the so-called safe harbour provision for the best interest duty on financial advisors should be retained or changed in any way. And one of the questions that was raised by the ALRC in the first interim report was whether the safe harbour provision should be recast as indicative behaviours of compliance. So I think the quality of advice review will assist to answer this question and others with which we're concerned. Other areas in which I think it'll be important or relevant are disclosure and how to reduce complexity while giving consumers access to clear and concise information. All of these areas are also very relevant to our inquiry. So thanks for that question. Another question that came in as people registered was from Andy Schmullo at the University of Wollongong. And Andy said he'd be interested to know what value, if any, the panel sees in adopting a plain English approach to drafting financial services legislation as a means to reducing complexity and promoting accessibility, such as has been employed in other jurisdictions. Well, it's interesting. Plain English or plain language is something that Australia's always held quite dear to its heart. I think we were quite early movers in this regard, certainly in terms of adopting plain language for commercial and consumer contracts in particular, but also, of course, adopting plain language for legislative drafting. And so it's quite well known in Australia, and I think one would say that we do apply plain language or plain English principles when we draft legislation. In my view, I think we need to expand our concept of plain English to cover issues that relate not just to words or expression, but also format, navigability, and coherence. In other words, and this is nothing new, it's not just about the words that we use, it's also about the way in which words are presented, the order in which they are presented, and how it all fits together within the legislative hierarchy and architecture. In particular, I think this issue of navigability is a central issue as we move forward with the inquiry. And that's because locating the law, as we've discussed, and understanding the law when you've found it, assuming that you have, all of that's grown in importance together with the length of the Corporations Act. And so all of those who work in this area would know that it's not a plain process for anyone to find the law and to work their way through the existing legislative framework. And that's the case even for those who are experts in this area. And so I think the work that we've done to date in the ALRC has reinforced these challenges, and we've discussed many of these during the course of this webinar. As I mentioned to begin with, and as everyone would be aware, the current version of the Corporations Act is very much the product of 20 years of additions, accretions, new regimes being bolted on, sometimes without having regard to the coherence of those new regimes with previous regimes. And I do think sometimes that difficulties arise as much in relation to the clarity of the concepts as they do in relation to the clarity of the language that we use. So those are just a few thoughts from me in relation to this interesting question of plain English and what role plain English has in the work that we're doing. So a third question, one that comes from Heidi Richards, discusses this interesting issue of XML, which for those of you who aren't familiar with the acronym means it's extensible markup language. So maybe you can use that in the next board game, Scrabble or what have you, when you're short of words to think of or to make with the letters that you have been given. But leaving all of that aside, the question that Heidi asked is what progress has been made in terms of converting legislative drafting into XML or other tools that can facilitate better drafting and textual analytics? And I'm pretty sure that this is a question that's best referred to Nicholas. So Nicholas, over to you, if I may.
Thanks, Andrew. No, it's a really good question, and thanks for clarifying the acronym as well. And I think also it's useful for everyone else's benefit that XML is just a format. So it's a way of making information, so text, both human readable and machine readable. So it's different from a PDF in that sense. And it opens up possibilities for converting law, so legal texts, into data and into a computer readable format. So it can bring a number of benefits that I'll return to in a moment, but it's worth noting that in Australia, it has increasingly taken off. So the Queensland and New South Wales and Tasmania publish their legislation in XML. Internationally, the UK, New Zealand, and the United States now publish in XML their legislation. At the Commonwealth level, we don't publish in XML, though we understand consideration has been given to it in the past. And it is a really big job to move an entire statute book to XML. But it's something that the ALRC has suggested may be worth it, that it does bring benefits. But in terms of other textual analytic tools, I mean, OSLE's been doing some interesting work as part of their DataLex project to experiment with rules as code. So that's quite an interesting area, and the Commonwealth government has some projects looking at that as well. the ALRC in its inquiry has been experimenting with some textual analytics in terms of, as we talked about earlier, trying to quantify complexity in legislative texts and also to explore legislative texts as data in other ways. And the purpose of that being to help drafters and policymakers in terms of thinking about where complexity lies within legislation and within the regulatory framework. And the ALRC, as I noted, all of these efforts are quite, and particularly XML and rules as code, are really big efforts. To actually get there is a mammoth task. And so the ALRC has really tried to make the case for some of these things. And in our background paper number 3, we really made the case for how technology and tools such as XML can open up all sorts of possibilities for improving the navigability of legislation. So even things as simple as hyperlinking, which are present in the UK and New Zealand legislation, or even annotations. UK legislation is heavily annotated to indicate where certain provisions have been affected by regulations or other instruments. And so that can bring immediate benefits in terms of reducing the day-to-day complexity of the law, even if some fundamental problems may still remain. So annotations, hyperlinking, XML opens up possibilities for marking up definitions and other, you could even mark up obligations or prohibitions or penalties in an act. And so that opens up all sorts of possibilities for RegTech and LegTech. And for thinking about, one of the key advantages of XML is, if it's done properly, is bringing consistency to legislative texts, and they're consistently marked up, and that's key for RegTech, so that every commercial provider or government provider doesn't have to go away and fix the document before working with it. So if the government can step in and publish legislation in a machine readable format, and in the US this has become a really big deal, government publishing in machine readable formats, that can bring immediate benefits to the public in terms of easier access to data, but also in the innovation that can come from the development of new technologies. So yeah, some progress, but still quite a long way to go, I think, in Australia in particular.
Thanks, Nicholas. We've had a question from Donovan Hutchinson at Westpac, who asks whether or how we can accelerate regulatory harmonisation. While key financial services regulators are working more collaboratively, harmonisation to reduce regulatory complexity and burden has been a topic for many years, but with seemingly little progress. So perhaps I could answer that question. As I've previously mentioned, the Corporations Act is very much the product of 20 years of accretions and additions and accumulations. And with the inclusion of new provisions, new regimes, often we haven't really worked out how to rationalise all of that with what came before, or how to ensure that it works effectively as a whole. And so we see, as Will mentioned and as others have mentioned, this issue of overlap with other legislation, particularly the consumer protection provisions in Part 2, Division 2 of the ASIC Act. We've also seen over the course of the past few years an increase in the areas in which regulators are co-regulating and co-supervising. Superannuation and the banking executive accountability regime are 2 examples of that. I think the ALRC inquiry is a good way of strengthening regulatory harmonisation in terms of achieving more effective cooperation and coordination between the regulators, and also achieving perhaps a more consistent approach. And that's because it's much easier to work with a more coherent, navigable framework, and it's much easier for the regulators to administer a regulatory framework that has a degree of coherence about it. And so removing unnecessary complexity and avoiding duplication, I think, will assist in this regard. We're also considering the broad architecture of corporations and financial services legislation, and whether it would make sense, for example, either to separate Chapter 7 from the Corporations Act, or perhaps to consolidate other statutes into the Corporations Act, perhaps in the form of a separate schedule, such as we have with the Australian consumer law. But I think this is probably a good point at which to look at the next question that's come in from Michael Tanganan at AMP. And I might direct this question at Chris, if I may, and that is, has the ALRC formed a view at this stage on the desirability or benefits of a separate financial services statute? And while we're on that question, Chris, another one came in from Chris Lim, which is related, and that is, how will the ALRC address the interaction between the Corporations Act and other financial services legislation, such as the SIS Act and the Insurance Acts? Are these acts within the scope of our inquiry, and how do we see all of these things coming together in due course?
Thanks, Andrew. I think those acts certainly are relevant, and it's a bit like a puzzle, really, with these pieces spread all over the place. And I think that's really what's due to be the focus of Interim Report C, where we'll look at how Chapter 7 in particular, but more broadly, the financial services legislation could be restructured or reframed. But the idea of having a standalone financial services statute is certainly something that's been raised with us. And it's something that I personally, as a user of the legislation, find quite attractive. I mean, it's quite frustrating when you go to the Federal Register and access the Corporations Act. You first have to figure out which volume out of 7, Chapter 7 is in. It's volume 4. But then, even then, once you get there, some of it's in volume 5. So it does have practical implications for everyday users of the legislation. I think it's fair to say, though, that it's not something that we've formed a view on at this stage. It's definitely something that would be considered throughout the inquiry and as part of Interim Report C. So far, people have expressed mixed views about it. Most are probably supportive, or strongly supportive. Some have even said that Chapter 7 should just be torn out of the Act and put somewhere else. But others have pointed out that even though Chapter 7 looks as though it's a fairly self-contained part of the Corporations Act, it does have these tentacles and these links to other parts of the Corporations Act. And so just taking it out may actually lead to some duplication or unforeseen complexity. So I think that observation really highlights that in thinking about these questions, we need to be really alive to the rest of the world, essentially, the SIS Act, the ASIC Act, and all of the legislation that's out there. In our 4th background paper, and I think in Interim Report A, we've also noted how the constitutional and historical background affects this question about what you could do with the Corporations Act or possibly a standalone statute. So since 2001, the Corporations Act has been underpinned by a referral of matters from the states under the Constitution. And within those referrals, there are limits on exactly what the Commonwealth is able to do when it's amending the legislation. And so those limits also have implications for, firstly, whether a separate statute would be possible, but also how you might move the pieces of the puzzle around within the existing framework that's there. But aside from a separate act, and I think as you alluded to before, Andrew, there are potentially other options for relocating or co-locating parts of the law. So, for example, as you mentioned, a schedule like the Australian Consumer Law could be used, where potentially Chapter 7 and Part 2, Division 2 of the ASIC Act could be consolidated, or alternatively, Chapter 7 of the Corporations Act could potentially be incorporated with what's currently the ASIC Act, in particular Part 2, Div 2, where the consumer protection provisions are. That Act could potentially be renamed and restructured so that it makes sense as a financial services regulatory act. But there are definitely pros and cons to all of the options. There's quite a bit of working through in terms of the consequences and the flow-on implications to be done. And so the key issues, I think, when we're thinking about these questions will really be about navigability and coherence of the law. Sure.
We've been speaking so far, Chris, about what you might refer to as horizontal navigability and coherence. The coherence of the framework as it applies across different pieces of legislation. we have a question that really deals with this issue of vertical integration, and in particular, it's directed towards the what the law might look like if our suggested approach were to be implemented. And so perhaps if I could invite you, Chris, and Phoebe, you might have something to say on this in relation to disclosure. But could you just outline again, please, the nature of the prototypes that were produced by the ALRC? You were very involved in that, I know, with Tom Reed, and the purpose and benefits of those prototypes and how people should read them and what they should get out of them in particular.
So in Appendix E to Interim Report A, we've put together a suite of example legislation which we think demonstrates most of the proposals, the key proposals that we put forward. So the first part of that prototype deals with the definitions of financial product and financial service, and it shows, as I discussed earlier, what they might look like under this new model, and how, for example, exclusions could be contained in what we've called an implementation order, which would be a piece of delegated legislation. So that's one aspect of the legislative hierarchy. The prototype legislation also shows, in the context of licensing in particular, how the Section 911A obligation could potentially be drafted in legislation, so that what are currently a whole raft of exclusions that just sit there in subsection 2 of the Act could actually be sensibly relocated to that same implementation order. And so that really, what people hopefully get out of it is a demonstration of how in practice this model would work for them as everyday users of the legislation. And then perhaps, Phoebe, I'll let you speak about disclosure in particular.
Sure. So yes, as I sort of mentioned before, it is just meant to be an illustration of how this could work. I think there is quite a bit of flexibility in the model, which would ultimately be sort of wielded by the policymakers in this space as to where you sort of draw the line as to what stays in the Act and what might be better shifted into an implementation order or another legislative instrument. But I think what it shows in disclosure in particular is that at the moment we have some quite prescriptive detail that sits in the Act. So for example, we have a list of, I think, A through M of the types of information and statements that a standard PDS must include. And then that particular requirement, along with quite a few of the other prescriptive requirements, it's often the case that they may not be applicable to sort of unique products and circumstances. So we get things like an ASIC conditional exemption from the Part 7.9 requirements, which serves to impose different disclosure requirements, which might pick up parts of Part 7.9. So you see things like the clear, concise, and effective standard for disclosure picked up from the Act and put into an ASIC legislative instrument, which serves to regulate a specific type of disclosure document. So I think what we're sort of trying to show with this model is that sort of detail which does get modified for different products and circumstances could be shifted into a lower level of the legislative hierarchy so that it could be adapted more readily. So you might have, say, a default set of content and form requirements for your disclosure document, and then you might have a whole series of tailored requirements for different products which are organised in that sort of way, and they would all sit within that one legislative instrument rather than across 84 ASIC legislative instruments and many, many schedules to the regulations plus the Act. So the idea would be that you would have your general obligation in the Act, and how you frame that would, of course, be another question. But at the moment, we've sort of tried to take what the law currently says and just sort of sketch out how you might keep some of that key detail in the Act, and then the the prototype drafting demonstrates how you could bring in some of the detail from the Act, as well as some detail from the regulations and from different legislative instruments, and just sort of consolidate it within one central place. So hopefully that will help people to sort of visualize what that sort of world might look like.
Thanks, Phoebe. I think probably as time is moving on, we've got an opportunity to ask one more question, and it relates to what Will was talking about before about the obligation to act honestly, efficiently, honestly and fairly. And this question comes from Simone Jacobson in Dawson Chambers, and I think you probably answered it to some degree, and that is, how will professionally differ from efficiently in relation to section 912A? And maybe I could just add a related question to that, Will, and that is on norms. And I know we talk a bit about norms in chapter 13 of the interim report, and in particular how we can articulate the norms more clearly. And you mentioned the objects clause as one example where you might have Australian financial services principles. Of course, two of Commissioner Haynes' norms are really already in chapter 7 in terms of the efficiently, honestly and fairly standard, but also the best interest duty to act in the best interest of the other. So perhaps I could just throw some of those questions at you in terms of where you think it's all heading and how you think it might help to adopt the approach that we've suggested in the interim report.
Thank you, Andrew, and thank you, Simone, for the question about the use of the word efficiently. So if you trace back a bit of the history of how that word came to be in the statute in the first place, it turns out that it has its origin in securities dealers legislation in New South Wales, and effectively it was intended that that traders would execute their trades efficiently. And for some reason, this language was picked up and has now come to have a life and meaning of its own, if you like. And I mentioned before how the very clearly established case law now is that efficiently, when it's used in the Act, in 912A and in the Credit Act, actually means competently or capable. Well, if that's the meaning that the court is going to apply, there is some value in aligning the language that we use with an intuitive label for that. So instead of having a word that actually means something other than its normal meaning, let's just choose a word with its normal meaning and use that. So that's the intention, is not actually to change the effect of the law in any way. It's just to try and make the law clearer and more accessible. So to use the word professionally, we suggested that word because it relevantly implies competence and capability, which is the meaning that the courts have ascribed. It would also align the legislation with some legislation in the European Union. And also, and perhaps most importantly, it's actually the word that is used in section 760A, which is the objects clause of chapter 7, uses that phrase as an object of the chapter in general, that it's intended for people to act in a professional manner. So those are the reasons why we suggest that we replace the word efficiently with professionally or competently to make the law easy to understand, not to change the effect of the law. And then, Andrew, you asked about the articulation of norms and how that could make the law clearer. Really, this is just picking up on an idea that Commissioner Hayne emphasised quite a lot in his Financial Services Royal Commission final report. And so at the moment, people are really trying to determine the overall intention or effect of the law by gleaning it after you've read the much more specific and minute provisions. And we just think that it could be useful to have effectively a signpost or a guide of what those principles are, which can help you get a better sense of what the more specific provisions are trying to do. And so, for example, in another context of the Corporations Act, many of the stakeholders that we consulted said that they found the so-called Eggleston principles, which are contained in the takeovers law, to be very helpful. And those principles have been heavily relied upon by courts in construing and understanding the more specific provisions. So it's really about enhancing the expressive power of the law. If we want people to comply with the law, let's at least, if we're not going to expect that they're going to read every single provision in great detail, give them the broad contours by giving them a set of simple principles or norms, such as those identified by Commissioner Hayne hopefully at the very outset of the Act, and that's the basic idea.
Thanks, Will. Well,
Thank you.
unfortunately, time has run out. And so what I'd like to do in just making a few concluding comments is first to thank all of my colleagues for attending today's webinar. But last but certainly not least, I'd like to extend a very sincere thanks to all of you for attending the webinar. Our work in this inquiry is very technical in nature, as I mentioned before, and that can be a bit hard going at times. But hopefully what we've managed to do, if nothing else, is to convey our enthusiasm for the subject matter and inspire you to engage with us as we move forward with our inquiry, but also, of course, to make a submission. It doesn't need to be a lengthy one, but engage with us on the proposals and questions that we've included in the interim report. And moving further beyond, of course, just to engage with us generally. So there's a deadline of the 25th of this month for submissions, but we're always interested to receive submissions, whether it be on a formal basis or informal basis. So please do maintain your interest, engage with us, and help us to move forward as we look at the other stages and work on the work that's been done to date. So with that, let me say thank you and goodbye, and look forward to seeing you at the next webinar. Thanks very much.